case and final case for the day is 18-3988, LALEAU versus Brevard County School Board. I apologize if I mispronounced the appellant's last name there. And counsel, just take your time whenever you're ready. No rush. Counsel for the appellant, whenever you're ready, just let me know how much time you'd like in rebuttal, and as soon as you start, I will try to remember to start the clock.
I believe 5 minutes.
5? Okay.
May it please the court. My name is H.B. Stivers. I'm here on behalf of the appellant, RONALD, LALEAU, and we're here today on the school board's dismissal of Mr. LaLieu's petition for an administrative hearing to challenge we refer to it as a labeling of Mr. LaLieu in his personnel file of the fact that pursuant to a determination by the school board that he is ineligible for rehire by the school district. Mr. LaLieu is a 21-year educator, spent the last 11 years with Brevard County Schools, and by all accounts was consistently evaluated as an excellent educator. There was a...
Has your client applied for reemployment?
He did apply. Actually, it's outside.
Now, let's talk about the record.
It's outside of the record. Yes, he has applied.
But let's just talk about what's reflected in our record, because that's all we can go off of.
Yes, and what we have, this case is, as I'm sure the court is aware, has been pending for some time. We are beyond 2 years at this point. Mr. LaLieu filed his petition.
I understand, but could you just... I just want to make sure I understand. On our record, has your client applied for reemployment?
I don't believe that's alleged in the petition that he actually has applied.
Okay.
Is
the designation? Is it your position that designation is binding?
Well, we don't know what the designation is. Okay. We don't. There's no rule. There's no statute. There's nothing that tells us why he's ineligible or what gave the school board or the employees in the HR. We haven't been able to do the investigation to find out where this designation came from, what's the basis of it, what supports it, and why are they allowed to do this.
Our record doesn't really reflect what would happen if your client applied for reemployment. In other words, is this designation is it an automatic denial of employment? In other words, if your client applied, and I don't know how hiring works, right? But let's say the principal did the hiring and the principal decided, yes, I want to hire your client. Would this ban that decision, or?
My belief is that and my understanding after representing teachers for several years now, is that a principal may find a teacher that they want to hire, and they then submit those names to the school district, to the superintendent, and to the HR department, who then pulls the file if they're a current employee or a past employee and sees what's there. What they're going to find in Mr. LaLieu's file is a designation in his file that says ineligible for rehire.
Right. But I guess what I'm trying to find out is the decision over at that point, or does our record indicate?
The
Is it
record
over,
doesn't-
or is that just a recommendation that could be overridden?
Well, at this point in our record, there's no indication as to what happens.
Either way.
Either way, I personally, I know what happens because
It's got to be in our record.
Exactly.
Yeah.
But it occurred after the petition was filed. What happened is this petition was filed on or about November 17th of 2017.
So if let's your client pretty quickly voluntarily resigned, right? Is that,
Yes.
I mean, how quick was it?
I believe probably within 2 weeks of being confronted by an employee.
And there was no investigation, or at least not a completed investigation. Is
Not
that
by the
correct?
school board.
Not by the school board.
Law enforcement completed an investigation and no charges or anything were filed. The Department of
But that's a little bit different ballgame, right, than the school district itself conducting an investigation, right? The
Typically what-
standards are a little different, right?
Well, the evidentiary standards,
Right.
of course, are different, but typically what happens in a school board situation, if law enforcement's involved, the school board sits back and says, what's law enforcement? Law enforcement are the professionals. We're going to allow them to investigate. We will then incorporate their investigation into ours.
Now, what would so I mean, so had your client not resigned, there would have been, I assume there would have been an investigation, right?
There would have been an investigation. There probably would have been
The school board would have conducted, or at least had the option to conduct its own investigation.
and the school board would have, even if he resigned, they could have still investigated, but they didn't. And in addition to law.
How would they, I mean, what would the purpose
There's a
be?
cost-benefit issue there. Why would they investigate? Would be to determine if there was something there. Is there something that they need to do?
Yeah, but if he's resigned,
And again, we're dealing with an issue that came forward about health, safety, and welfare of a child. And did the board need to take any other action? Was there anything else going to come out of this? I would hope to believe that there's nothing else out of it, because we're not even convinced that the initial allegation took place. And again, the sheriff's office investigated. The next step is the Department of Education, who licenses school teachers, investigated it. And they chose to take no action. And so there's never been a determination that the event even ever took place.
But if he'd have stuck around, they would have done that. They would have had to have done that,
Well,
correct?
if he would have stuck around, potentially what happens is the school district takes law enforcement's investigation, they take potentially the Department of Education's investigation, conducts their own investigation potentially as well, and then the superintendent makes a recommendation to the school board on, are we going to impose some sort of discipline? Are we going to suspend them?
Say they terminate him.
If they terminate him?
In that case, it's clear he gets his hearing, correct?
Yeah, that case is clear. He gets a hearing. And at that point, well, it's twofold. He either gets a 120 hearing if he chooses to go the 120 hearing route, or he can pursue his rights of just cause under the collective bargaining agreement and go to arbitration. Now, he is the court's well, or he can't do both. He's got to do one or the other.
I'm struggling with the resignation, counsel, as it relates to just what could at least be argued as a discretionary decision to list somebody as ineligible for rehire. Is your position that any time a school employee is listed as ineligible for rehire, no matter what the reason, they're entitled to a hearing?
Well, the question we have is, we have looked and looked, is to determine under what criteria does the school board have to place somebody as being ineligible for rehire? Is there a statute that allows somebody, because the legislature's clear, here are the qualifications for employment.
Well, I guess that's my question.
Here are disqualifying
Is your
offenses.
client's position that any time somebody's listed as ineligible for rehire, no matter what the reason, that they're entitled to a hearing?
If they are, and again, I think it's potentially yes, that would be the answer to that, but the question becomes, what authorizes the board? If the board doesn't have the authority to label somebody as ineligible for rehire. Now, I understand there are situations, and we have done that, where people have entered into, we call them separation agreements from a school board, and they will agree that they will not be eligible for rehire. That's part of their separation in a contract agreement. That was not evident in this case. This was just the unilateral decision of our belief is somebody in the HR department up through the superintendent that says Mr. LALEAU is ineligible for rehire. There's no statute that supports that. There's no school board rule. There's no school board policy. There's nothing to tell people out there that if they resign, that they're going to be ineligible for rehire, or if they resign under this circumstance or this circumstance or this circumstance. There's nothing that would advise the employee that, hey, maybe I'm not going to do this, because there's no guideline for it. It's just, Mr. Stivers, we don't like you anymore. You resign, boom, you're now ineligible for rehire. For whatever reason. They didn't like the shoes I wore one day. I don't know. It's anything. We don't know what the basis of it is. And that was one of the things that we were hoping to ferret out is, what's the support for this? Is there some statute that you're relying on? Is there a policy? Is there a rule? Because if there is, we can't find it.
Counsel, if we're of the mind that by resigning your client lost his rights to contest that, what would happen if he went to the BREVARD school board tomorrow and applied, and they said, well, we're not taking your application because you're ineligible for rehire? Would he have any rights to a hearing then?
And I believe what we have found, I would argue that he would, because in fact, again, we're outside of the record, but in your hypothetical, he did apply and was turned down. And so,
well, my question is, laying aside whether that in fact did or didn't happen, just hypothetically, if he applied, and they said, we're not taking your application because you're ineligible, would he have any due process rights to a hearing at that point?
I think the question becomes is, why is he ineligible? What's the basis for him being ineligible?
Well, I guess that's my point is, would you have an opportunity to litigate that if he applies and they say, we won't accept your application because you're ineligible? Would you then have a right to litigate their ability to label him, as you called it, as ineligible?
I would think that we would, because I think that's because you're out there, and what we have here is we have an employee that was at this district for many years, and he did resign. After the resignation is when what we call the labeling occurred. When it first came out, we sent letters saying, look, we have an issue with this. We want to know, what's the basis of it? Why are we doing this? Why are you doing this? What's your authority for doing it? And there was no response. We filed our petition for hearing. Again, we filed a petition for hearing seeking, we want to know, and we want to challenge this designation, because this is going to have an impact on us. And it's going to affect future employers, because this is in his personnel file, and as a school teacher, his personnel file is subject to public disclosure. And any future employer in a school board is one of the things they're going to do is pick up the phone, or they're going to request his personnel file from the Brevard County Schools. And someone who's taught for 11 years, they're going to say, why is he ineligible for rehire? And I assume they're going to be told why, but we've never been told why. And he's never had the ability to challenge the why. And that's what the petition is seeking, is for the ability to challenge the why. Why is he ineligible? This has an impact on it. It affects him directly. This is not, he's not here trying to say that this is a big policy and I want to get everybody that this may have happened to. He's not this isn't a third party coming in trying to do it. This is, Mr. LALEAU trying to figure out why this designation was made. I mean, we all have our beliefs as to why it was made, but there's nothing in the record to tell us why. There's nothing has been put forward as to the reasons, the rationale, or the basis, or the authority for it. And again, this is the only way he has to challenge it is through the administrative proceeding. And it is his substantial interests that are being affected. And again, in this, as I know you guys are well aware that this has been lingering for some time. We're now beyond 2 years from the date that the petition was filed. It took the school district over 150 days to even consider the petition. Once the school board voted on...
I was unclear in your brief. You did raise the delay, and you argued prejudice from the delay, but what is your position what's the end game there, right? Do you argue that because of the delay that we should not only reverse, but also that you should prevail on the merits as well?
I don't think that would be proper for us to ask the court for us to prevail on the merits. As much as I would like to, I don't think it's proper for this court to say that because the merits have never been heard. I think the issue of the prejudice would be heard by the administrative law judge, because now we're at a situation where, we have the typical issue of time, witnesses. Are we going to be able to find witnesses?
But those things go to, right, if you reach the merits.
That would be, I think that would be at the hearing on the petition.
Right.
And those issues would be raised in front of the administrative law judge. I don't think it would be proper for this court to say the delay means that the school board's order gets reversed and we win on the merits. Mm-hmm. For whatever reason, that just doesn't seem right.
Your point is, if you get to the merits, the delay has potentially prejudiced your client.
Yes.
But that's if you get to the merits. So I guess what I'm wondering is, if we conclude that otherwise the order should be affirmed, but then we look at the delay, is your argument that even if the order is otherwise proper, the delay alone, the prejudice that you've suffered from the delay should require a reversal? But the prejudice you identify only comes into play if you get to the merits.
Well, but I think the prejudice, and I understand where you're at, but I think under some of the previous cases where there's been significant delays, where they haven't been, they've never really reached the merits, but where the issue is not the ultimate relief that's granted, it's whether or not the hearing should have been granted. And if the hearing should have been granted, then we should be entitled to a hearing. One of those issues then becomes the prejudice that a party has incurred. And when you have a party that's waited, and I believe I'm horrible with case names, I apologize, but there's a case where it took 9 months for an order to be entered. And during that time, you had an individual who didn't have a hearing, was unable to maintain their license, had lost wages, many of the issues that we have, unemployment, unable to get wages. We don't have the certificate and licensing issue because the department didn't take any action. We have those issues that says, well, that is a reason to grant the hearing. It's not a determination on the merits, but it says because of this delay, yes, you should have gotten your hearing. Therefore, we're going to allow you to have it.
Counsel, you're into your rebuttal time. Do you want to save?
Yes, please.
May it please the court. Good morning. My name is Shannon Kelly, and I represent the appellee, the Brevard County School Board, in this matter. The appellant in this case is asking for this court to find basically that the Administrative Procedures Act itself guarantees the right to an administrative hearing absent any entitlement whatsoever in substantive law.
Does the fact that you reported to, I guess it went to the State Department of Education, the form that says something like, was titled, I think, like employee misconduct or something like that, employee misconduct report, and it doesn't say anything about the facts, it just says this employee is ineligible to be rehired.
Yes.
Does that create a stigma that a reasonable employer, a future employer, would hold against Mr. LALEAU? They get this, they look in his personnel file and they see this employee misconduct, ineligible for rehire. Does that create a stigma that he hasn't had a chance to contest or clear his name?
Well, there's two parts to that. First of all, the reporting is a statutory requirement. Anytime there's allegations of misconduct against a student, that has to be reported to the Department of Education. In this case, the most important fact in this case is really the fact that Mr. LALEAU resigned while under investigation. And that did a couple of things. That, made it where there really was no determination about the factual allegations involved, and it also really terminated any relationship, the employment relationship between the school district and Mr. LALEAU. And
What rule or policy or statute gives rise to this designation ineligible for rehire? Who makes that determination, and what standards do they use in making that determination?
Well, it's our position that this determination, first of all, it didn't go before the school board itself to make a vote. So it's our position that there was no agency action at all in this case.
Well, somebody made the decision that he was ineligible to be rehired.
Right.
I don't know who. Could have been the janitor, could have been the superintendent.
Well, that's not necessarily in the records, but I assume that it was someone in human resources. There's an associate superintendent of human resources.
Are there any standards or policies or procedures in place that would inform the decision maker of what they should look to in making that determination?
Well, I think that it's basically under the discretion of the school district. I mean, in this case, the reason it happened is you have someone who resigned while under investigation. And I know there were some questions about, well, could have we continued to investigate? Yes, but we could not also compel Mr. LALEAU to participate in that investigation.
Well, I guess the bottom line is, do you think that a reasonable person would view this ineligible for rehire designation as creating a stigma that would preclude him from future employment opportunities?
Well, I think arguably, in this case, potentially it could create a stigma, but that's not the standard. In the appellant's initial brief, they raised for the first time this concept of a substantial interest being created because his liberty interests are implicated. And the point with that is you basically have to prove stigma plus. We're talking about liberty interests under the United States Constitution. And in order to show that, he's got to show stigma plus.
But hasn't the U.S. Supreme Court recognized that when it's government action, that the foreclosure of future employment opportunities creates, when it's accompanied by some sort of, they call it a badge of disloyalty or infamy?
Well, in this case, our position is that's purely speculative. The cases, involving entitlement to a Chapter 120 hearing by the implication of an employee's liberty interests are readily distinguishable from the cases here.
What do you think about the Yunker versus University of Florida case? Apparently, Yunker was on a year-to-year contract. They told him they weren't going to renew because he wasn't going to get tenure, so they were not going to renew him.
Right.
And apparently they wrote a letter that says something, we're not renewing you because, the faculty doesn't like you or whatever. It's not clear. And the district court, the first district, said that that was enough to give him a name-clearing interest. He was entitled to a hearing to clear his name.
I think the difference in that case versus this case is the fact that the action began with the employer. Mr. LALEAU resigned, and at that point, any contractual or employment relationship between the district was terminated. The designation
What would happen instead of just simply saying ineligible to rehire, if they had sent a report that said he's a child molester and a no-good skunk? Would that give him any opportunity to come in and we don't know who said that, or why they said it, or on what evidence they based it, which is kind of similar to what we have, although what they said isn't nearly as bad as he's a child molester and a no-good skunk. But if they said something like he's a child molester, would that entitle him to a name-clearing hearing even though he voluntarily resigned?
Well, I think that that's different because that's clearly a defamatory statement. I think there's two factors with the liberty interest case that we disagree with. First of all, the 5 factors in the Buxton case, there has to be a false statement of a stigmatizing nature attendant to discharge that was made public by the governmental employer. Obviously, in this case, we don't have a discharge, and there's not even a false statement. It's our opinion as a district that he is ineligible for rehire. We don't give the reasons for it. Candidly, the reasons are that he resigned while under investigation, and we couldn't come to a determination either way as to the, whether they were true or not. And, that was his choice, clearly, to resign, but it's also our choice to say, you can't really avoid, we were unable to complete our investigation, so it's a risk for us to have you back without the ability to have done that.
Would he be entitled to a hearing, hypothetically, if he walked in tomorrow and applied for a job and they said, we're not going to consider you because you're ineligible?
I don't think he would, because his substantial interests haven't been affected because there's, basically they have no contractual relationship. In all of the cases, the appellant cites a number of cases relating to licensing issues. Clearly that is different than this case. All the employment cases, here, one that I would mention, the Herald versus USF case, the assistant professor was denied a full professorship. He maintained his employment, and the court basically said that, damage to his professional reputation did not constitute a substantial interest entitling him to a DOA hearing. Same with the Sikon versus Alachua School Board case, where a teacher asked for a DOA hearing related to a band director position. They maintained their employment, but they wanted this other thing. In our case, we kind of have the opposite situation because there's no relationship whatsoever, so there was nothing to change about it. There was no affirmative action by us to change any contractual or employment relationship because we have none. It's our position that he's really articulated no substantial interest in this case. There's been no injury in fact. That's a question of substantive law. The cases are very clear about that. The appellant has cited absolutely no substantive law on appeal or in the petition that would entitle him to an administrative hearing. The ASI Inc. case that we cite in our brief clearly establishes the procedural requirements established by the Administrative Procedures Act do not confer the right to an administrative hearing. There has to be an actual or immediately threatened injury. The allegation that he's experienced economic injury or his employment prospects have been harmed, it's purely speculative. There's nothing about that in the record. And the second factor in determining whether substantial interests have been affected are that the injury is not the type that the statute under which the agency acted is designed to protect. It's our position that the school board didn't act at all in this case. This was an administrative designation by Human Resources. But even assuming that there's a determination that the school board did act, it's basically under the statutory discretionary authority. Florida Statute 1001.49 gives superintendents the authority for general oversight of the district school system. Florida Statute 1001.32 says that a school board is permitted to exercise any power except expressly prohibited by the Constitution or general law. So they've raised, clearly it would be a different situation if we terminated his employment or took some affirmative action, but the most important fact in this case is that Mr. LALEAU resigned, and at that point, we took no affirmative action whatsoever. I want to mention briefly the concept of delay, and admittedly, there was a significant delay in this case, and I think a lot of that can be attributed to the fact that the school district looked at this petition and really did not understand what it was asking for. It had never received anything like this before. You know, as we've talked about, you know, it's our position that he hasn't alleged a substantial interest. There was no realization that they really needed to act on it. And it's our position that certainly if he had no legal entitlement to this hearing to begin with, there was no prejudice. And, you know, while the delay was unfortunate, it certainly shouldn't be dispositive in this case. One thing I do briefly want to mention was there was the argument that Mr. LALEAU was not given the opportunity to amend his petition. The school district's final order admittedly doesn't use those words, but what it does say is that the petition is not legally sufficient. And under those circumstances, Chapter 120.569 really only requires that amendment be permitted unless it conclusively appears from the face of the petition that the defect cannot be cured. In this case, you know, our position is that there's a lack of standing, nor is there a substantial interest, and an opportunity to amend certainly would not have cured that. And I'll stop there, unless there's any further questions. Thank you.
Thank you, Counsel. All right, Counsel, you have 3 minutes and 16 seconds.
Thank you, sir. Briefly, in response to the questions that Judge Orfinger had regarding the misconduct form, those misconduct forms are a statutory form. They may not be statutory, but they're by rule. The department requires the school boards to report certain activities that go on so that the department becomes aware of them, so they investigate them. Rarely are they marked with somebody being ineligible for rehire. That's something that is apparently somewhat unique to the Brevard County School District, at least in our experience. It's something that is not typically done. Some of the cases that were mentioned, the university cases, if I can, 1 second. The Herald case is one where a professor went up for to become a full professor, was denied, asked for an administrative hearing. They said, you're not entitled to an administrative hearing because whether or not you get full tenure is not something, there's no stigma to that because you're still employed as a professor, you're still there. If you compare—
There's a case out of the 3rd DCA involving a community college professor whose term was not renewed. And what the 3rd DCA found is that there was no substantial interest there because it was a discretionary decision not to renew. How do we address that case in light of the resignation?
Typically, a community college professor is on an annual contract. In an annual contract situation, you have no continuing anticipation of future employment.
But it would be a discretionary decision not to renew that contract.
Yeah, and
correct?
there are school teachers on annual contracts that if anybody hired as a school teacher after 2011 is on an annual contract. If that annual contract is non-renewed, there are basically no ways to challenge that through a DOA proceeding. Now, you may have other actions if there's some discriminatory basis or something to challenge those, but the statute's pretty clear. You have very limited review of somebody on an annual contract.
Ineligible for rehire decision was based on some sort of discriminatory animus. You'd agree that there would be some relief?
There would be a relief outside of DOA. There would be relief somewhere else. Now, in getting back to my professor, there's another case where a professor was the dean of a college and he was removed. And in challenging the removal as a dean, he was granted a hearing because the courts found that when he's removed from a dean, and comparing that to the Herald case, He now has a stigma to him that may be out there in the community. It may be negative. He has a right to challenge that to see what the basis was so he can contest the basis of why he was removed as a dean. So he still had his employment. Mr. LaLaue doesn't have his employment because he did resign. However, I think he still has the right to challenge it. The SICON case was a discretionary, that was a position that is a supplement, that is something that's done at the discretion of the school board.
Thank you, counsel.
Yes, thank you.
All right,
Thank you both.
thank you. Have a good day. We're in recess.